All right, we're live. Senator Sears, I'll turn it over to you after the questions I had, and if you had any further comments.
Well, I think that there's the Justice Oversight Committee is currently looking at the state paid deputies and the usage of those deputies during the pandemic, and now that most of the arraignments are being done virtually. And but I don't think it would be a bad idea for the Joint Fiscal Office and our Legislative Council to take a look at this, and perhaps a meeting with this committee, the Judiciary committees, or Justice Oversight, if we can talk to Representative Emmons about having a special meeting on it. Because we put, as I think Allison, Senator Clarkson mentioned, we put a tremendous amount of money into helping them out. I think it was 16 million between the Judiciary, state's attorneys, and the Defender General to try to help them with technology and et cetera to get through the pandemic. And I heard that Windsor County is also having some problems. That I know Bennington County's had a shortage of deputies, which has meant that we have fewer hours. I believe Windham County had some issues, and as Joe mentioned, the Kingdom has a number of issues. I've heard from the state attorney in Grand Isle County, where they've cut them back dramatically. So I think it's something that really involves. You could either I would ask at this point the Joint Fiscal Office as well as the Legislative Council to look into the issues, and then either I guess Joint Justice Oversight, this committee, or any other committee. Either Judiciary.
Thank you, Senator. So I think that there's probably agreement that we should into this particular issue. Where precisely the right venue is for us to take it up. I don't think we have to decide that right now. We can work with Legislative Council and Joint Fiscal Oversight, like you say, to figure out where. I will just add one item with respect to the Administrative Order 49. I do believe it is certainly within our look at that order. I think there's no doubt about that. But it is an order that is already in existence. And if we were to look at it, we would be looking at it pursuant to Section 3D of Title 12, or is it Title 1?
Title 12.
Title 12, Chapter 1, which allows this committee to conduct public hearings, object, and notify the court of objections concerning existing rules. But the catch is that the rule reviewed under the subsection shall remain in effect until amended or repealed. The Judicial Rules Committee does not have the authority to amend or repeal. That would have to be done through the legislative process. Somebody would have to introduce a bill, or it could be amended or repealed by the court itself. And that also leads to my, at least as far as administrative order and the issues raised regarding the administrative order, I would prefer to wait until the court has addressed this issue, because it is in front of the court right now, and see where they go with this, whether there's going to be an amendment or repeal before we decide, at least in looking at the administrative order 49. Although I agree we have broader issues to look at and we should pursue those. The one other point I would make is that I would rather have the court look at the issues with respect to Administrative Order 49 first, because I would like to see the court's view. And because this is in litigation, we can ask them to share their review or their view with us right now, but they won't, because it is in litigation. So the way that we can understand where they stand is for the court
join the meeting
in the litigation. So in any event, I think we should move on from this. I will work with Senators Benning and Clarkson and also Legislative Council to figure out the best way forward in getting some sort of hearing together to address the broader issues. So any other point on this at this point, or should we move ahead to the schedule so we can get Judge Tomasi out of here in time for his hearing this afternoon? So over to you, Judge Tomasi.
Good afternoon. Can you hear me okay?
Yes.
Okay, thank you. Chair Lalonde, Vice Chair Benning, members of the committee and Legislative Council. It's an honor for me to be here. I am Tim Tomasi. I'm here on behalf of the Committee on Public Access to Court Records. Appreciate the opportunity to present these rules to you. They are still out for comment. They were proposed on the 16th of September, and the comment period ends in November. If it pleases the committee, I thought I'd just give a brief overview of the rules that are being proposed, and then open it up to the committee to give you a chance to ask any questions that you might have for me.
Please do.
The first couple of changes are to Rule 5C and D. Essentially, this fixes a gap, if you will, that was an oversight, I guess I would call it. Typically, people in cases who are connected with it, attorneys, GALs, have full access to all the materials that are part of the case. There are certain circumstances, though, when there's a filing that is made where you don't want the other side to have access to it for whatever reason. There may be a law that allows that. For example, if you were trying to seize a bank account from in a civil case and you didn't want the person who had the bank account to be able to know that you were making that request of the court because the person might empty out the bank account, you can make what we call an ex parte filing, which really doesn't go to the other side. Similarly, there are other times when you have a submission that the judge herself is going to be the one to be reviewing without access to the other side before determining whether there's going to be a production to the other side. That's an in-camera proceeding. And under the old rules, we didn't specifically say that those were that attorneys on the other side and GALs who were in the case would not have access to those. So this just clarifies that if you are in one of those unique, special, limited circumstances where you are making a filing that a rule or a statute permits to be done without giving notice to the other side, that the other side is not given by these rules access to those records. The next few amendments, 6B, 20, 21, and 22, all those have to do, as you know, there's a presumption of access, public access to public records in the judiciary, to court records. Rule 6 contains some of the principal exceptions to that. These are these amendments here. The first two, 620 and 21, really kind of go hand in hand with the examples that I just gave you a moment ago. The circumstances where there is either an ex parte filing where you don't want either the other side or the public to have knowledge of it, or an in-camera review, again, where you would not want to have the public or the other side have an opportunity to review those materials, at least until the judge makes a ruling on them. So that these would say that if the law allows you to make those kinds of filings, then until they're done, that those are exempt from public access. Similarly, under 6B 22, there are circumstances where the law statutes give principally statutes give trademark protection or trade secret protection and confidential business information protection. This essentially makes it clear that those are protected from public disclosure. And we've noted a couple of different sources of information or sources of authority for that under the Public Records Act, and also under Title IX, which gives some specific definitions of what is and is not a trade secret. And what is or is not confidential business information. Obviously, over time, there may be some glosses on those put on by court terminations going forward, but this just recognizes that there are certain documents that the law recognizes as being confidential and that recognizes that pre-existing statutes. The last set of amendments have to do with Rule 9. Rule 9 essentially addresses two kinds of motions. One is to seal records that otherwise would be public, or to unseal, and the other is to unseal records that have been deemed to be non-public. This amendment here makes a somewhat streamlined process in light of comments that we'd received both from certain members of the bar and from judges, that the former system was a little bit difficult to maneuver and the deadlines were hard to meet, and especially so that there were oftentimes difficulties in meeting them as it related to materials that few would have actually contested. Because under the old rule, it had to be the presiding judge who would make a determination as to whether or not to address a motion under Rule 9. You always had to set a hearing, no matter what. Had 14 days within which to schedule the hearing, and you didn't have necessarily complete briefing by the parties or the lawyers on the issues presented. So these changes, they still require the court typically to set a hearing as soon as practicable, but allows the parties to brief the motion in advance of the hearing. In addition, any person can ask for a hearing, and certainly the person who may be the subject of the records can request that hearing. And typically we envision that a hearing would be held, but the new rule does allow the court to seal if it is stipulated to, or if there's no request for a hearing. But even in that circumstance, the court must still go through the process of determining whether there's good cause for sealing under the traditional First Amendment and common law right of access sort of balancing tests. And we also included a safety valve for those circumstances that if there were a circumstance where the judge had not specifically held a hearing, it allows for anyone at any time to be able to request a hearing for reconsideration of the judge's ruling. And that's a de novo hearing. We made that clear that there was no prior, there's no standard, there's nothing precedential about the initial determination. Essentially, you'd be having the original hearing that you could have pursuant to Rule 9C. Rule 9C makes clear that the same hearing would be held if you were trying to unseal a matter that is non-public, and that 9E clarifies how one would take an appeal and what the process would be to take an appeal from these kinds of rulings. Overall, the committee felt these were reasonable changes that met the needs of the docket to protect the reasonable expectations, both of confidentiality and of access, and to provide an efficient mechanism for judicial oversights of requests both to seal or redact or to make public non-public records, all in keeping with the traditional common law and First Amendment rights of access and the balancing tests that the courts have imposed both in Vermont and elsewhere for that determination. So with that, that's the thumbnail sketch, and happy to chat about anything the committee would like.
Any questions from other folks? I had a couple questions. I'm looking at page 5, the comments on the rule 20B22. It says in the comments about 1 VSA, it actually should say 317 C9, not 7 C9, but that's not my question. It talks about not binding on the judiciary and also arguably ambiguous and or incomplete. Is that kind of a request for the legislature to try to make this complete and non-ambiguous? Or I just was kind of curious about that statement regarding that statute. Is that something that maybe this isn't the time where you're able to answer that question, but is that something that the legislature needs to address to make, or are the courts handling it just fine in interpreting the language themselves?
It's funny that you picked out that particular sentence, because I thought that only a lawyer could have written that sentence this morning when I was reviewing it again, and I was thinking probably should have made a different sentence on that one. I think most of that came from I think we were looking for some guideposts, and obviously 317 is a guidepost. We were Tanya Marshall, who was in charge of public archivist for the state, serves on our committee. And she was also indicating that over the years that there had been quite a number of questions, maybe that they hadn't percolated to the judiciary, but that she felt that there was some ambiguity in that particular thing, that in that particular section that had we didn't get into specific details because we weren't thinking about making a recommended change at that point, but that she was saying there was some ambiguity there, that she would like addressed. And so I would sort of maybe leave it at that. We tried not to go down that gully hole because it did seem like a guidepost that was reasonable. And certainly there, for the few cases that had addressed it, had provided some interpretation of that language that we thought was okay, but we thought we would flag the language because of her concern.
I appreciate it. I guess I'm just being too sensitive on behalf of the legislature when people call our legislation ambiguous and incomplete. So I think my more substantive question is actually on page 6. I had a question under subsection 4, but there's a couple other places where the term non-party is used. And I'm wondering if the term non-party is limited by section 3E, where it talks about parties and any other individual who is subject of the information. Is that language in 3E limiting who a non-party can be?
I don't believe we intended to limit it in that fashion because I think, for example, media, I would think would have an opportunity to make such a request as well. So I don't think our intention was to confine it to 3E, but to just say anyone who has an interest can make the request.
Yeah, and I guess part of the reason I asked that is actually in the comments. Trying to find it in page 9 I'm looking at. We're talking about revised paragraph A3E. Persons other than the parties who are entitled to notice and opportunity for hearing. I just thought I thought that that's probably was the intention, was not to foreclose the media as another non-party. But I thought that with that comment, it made it a little bit ambiguous to me.
Okay.
If there can be clarity that
Yep.
not limited.
I think that's a reasonable point. I think that would be reflective. Your view is reflective, I think, of the committee's understanding.
I think that's any other questions? I think we're good. Do we need to take, I mean, we can't take any action on this, Eric, but if we had a quorum, would we have to take action on this?
No, because they're still in the proposed stage, so they have not yet been promulgated. So
Okay.
in theory, the comments that committee has made will be considered by the committee before promulgation.
Okay, great. Thank you. Thank you, Judge.
Thank you.
So I believe next up is Judge Morris is standing in for Emily. You are?
There's Emily right there.
Excellent.
I'm along for whatever she might not be able to say, and I'm confident there is nothing that she can't say addressed to this package of rules. Thank you.
I'm Emily Wetherell. I'm the Deputy Clerk at the Supreme Court. I know on the agenda, Justice Dooley is there, and he's sorry that he couldn't make the meeting today. He was triple booked. So he's trying to do 2 other things at the same time as well. I appreciate the committee's opportunity to speak to this. I think the committee looked at these rules at the last meeting when they were in the proposed stage. So
yeah,
I won't go into great detail, but I'll give you just a little bit of an overview of what the rules were concerning and a couple of changes that were made since they were proposed. And if the committee has questions, I'm happy to answer them. It's really a package. The 28 appellate rules that were amended, and then several of the e-filing rules that were also amended. This was part of the implementation of Odyssey and e-filing at the Supreme Court. And the committee might recall that Justice Dooley went into some detail last time describing the process of creating these amendments. It did include some court personnel. So me, for example, from the Supreme Court side, some of the project team, and then we also had appellate lawyers both in private practice and who worked for the Attorney General's office involved in the process, including someone that was designated by the VBA. So I think it was a really good collaborative process. During the comment period, there was just one comment that was received. That was from Judge Tour. I think Justice Dooley mentioned that last time. There were no other official comments, and I think part of that is because the committee also worked with the Civil Rules Committee and got some more informal commenting from some of the other rules committees to address whatever questions came up from that. So kind of an overview of the changes that were made to the appellate rules. There were changes in definitions and terminology that were necessary, moving to a electronic case management system instead of a paper one. So new definitions for e-filing fee. We had to remove old words like original and paper and mailing and that kind of thing. One of the changes that happened since the proposed rules, Representative Lalonde had questioned, maybe we could update some of the language like informa pauperis, which is something that had been done in the civil rules. So we took the opportunity to do that as well, to update some of that older language. There were lots of changes that were made regarding the entry fee and the timing of that related to e-filing to make everything more uniform across the different kinds of appeals for interlocutory and discretionary appeals. And then there were a lot of updates related to the record on appeal because we're getting an electronic case from the superior courts. We don't physically now have to wait for them to send us a box. We do have cases that are not electronic records. They're not from superior courts. They come from executive branch administrative agencies and boards. And so there are some different rules in there related to the record on appeal for those boards and agencies. And then related to that, we had to update some of the rules regarding the printed case, which is what some appellate courts call an appendix. It's sort of a compilation of the main documents that are from the trial court case, and the appeal volume, which is a new document. We've got a new definition in there for the appeal volume, but that appeal volume takes the place of the printed case when there is an electronic case file from the trial court. We also updated the rules on service and certifying service so that at the Supreme Court, those rules would be the same as in the trial courts. Lawyers have, it was a little bit rocky, I think, at the beginning regarding service and certifying service with e-filing, but we wanted to make sure that those rules were the same at the Supreme Court so people weren't having to learn a different system on appeal. And then there were a lot of changes regarding formatting of briefs and motions to optimize reading electronically, and also to get rid of requirements like color covers on briefs. They don't have to do that anymore. No filing of paper copies anymore, because everything is an electronic document and will be read electronically. And then the last two sort of major headings are updating those stipulations to extend time to make that a little bit more uniform and clear, and some updates regarding public access. This was really codifying stuff that had already been done by practice at the Supreme Court, but we wanted to clarify that when there are oral arguments regarding cases that are confidential, so juvenile cases, mental health cases, that those arguments are public, but the people's names cannot be used during the argument. And then regarding public access for agency records. Did you want to, do you have a question?
So, Emily, before you go zooming ahead here, because I know it's a long.
I know, it's a big
long
package,
report.
and I'm happy to go into more detail if you want.
And in some ways, we had our e-filing discussion a little prematurely because I hadn't realized this was going to go into this depth. I guess I have a couple of questions for you, given what I asked before. But on the e-filing fees, does Ways and Means and Senate Finance, do they review these as fees? I mean, do we get an opportunity to weigh, does the legislature get an opportunity to weigh in on the fees? And will they be built into and baked into our 3-year review of fees, which normally before some things changed and before the Scott administration decided not to be very excited about fees. I mean, we normally had all the fees on a rotation basis and we reviewed them. Will these e-filing fees be approved by the legislature? I know there's been a discussion of them in the past, but I don't serve on judiciary.
Yeah, so I'm probably not the person to be testifying regarding the e-filing fee. That fee was negotiated between the judiciary and Tyler Technologies.
But was it negotiated
and so
with the legislature who sets fees in the state?
I'm not the one to probably talk about the status of that negotiation, like what the legislature's role is in the,
Right. Cool. Maybe send it.
I can comment.
Yeah, thank you, because I know it was an issue.
We passed a bill this year that will require the judiciary to come before the normal fee process on these fees when they're renegotiated. Secondarily, the entire process of the Odyssey fees, et cetera, was done outside of legislative purview or administrative purview. And it was quite an area of disagreement between the legislature and the judiciary. But it is what it is.
And so we're moving forward that we'll review them.
They would be reviewed by the normal committees.
Right, okay, great, terrific. That sort of was my question, is they, are they now going to be?
I don't remember the bill number, but Eric could probably.
Yeah. Okay, great, thank you, Dick.
Welcome.
Sorry, I just had that. And then the other question I had for you is, when you say comments, how does, given all the comments I've gotten about e-filing, how come those aren't all coming through your system of collecting comments? Do you reach out directly to all users of the judiciary to get comments, or just to, because why am I getting comments you're not getting?
So when I'm referring to comments that were received on the particular proposed rule changes. And those rule changes go out to all members of the bar, and then all of the court comms and clerks throughout the state. In some instances, there's an administrative order that states how those how we disseminate and who should receive notice of those proposed rule changes. So in some cases, there are notices that are placed in newspapers or things like that. And then they're put on our website, the comments.
So they
to receive.
require people coming to you and or seeing the, they aren't necessarily emailed to the bar or to
They're
everybody.
emailed to the bar. Every member of the bar receives it. Mhm. Yep. And if it's a rule of more general applicability and not just something that would be of interest to the bar, then that's when the court would place a notice in newspapers. We've had public hearings on some of the rule changes in the past as well.
But not on the e-filing system in total and how it's
No,
working,
there
just
are-
on these rule changes.
Right, that's what I'm referring to right
Yeah,
here.
no, I realize.
There are
that.
other mechanisms that the judiciary is using to collect comments on the system more generally. But these particular comments I'm talking about are as to the rules. As particular to the appellate rules, we had a bench bar meeting as well, an appellate bench bar meeting while the rules were out for comment. And during that appellate bench bar meeting, we went through all of the proposed rules and also, encouraged the bar that if they had comments to submit those comments, either there at the bench bar meeting or later, by email or whatever other method.
Thanks.
Was that?
Yeah, for the
Thank
moment.
you.
I'm not sure that I missed anything. I guess the other thing that I was just going to mention is that those few amendments that were made to the electronic filing rules. Those were just a few areas where we had to make sure that we included the Supreme Court in the e-filing rules, and that there were a few areas that were a little bit different related to the implementation of e-filing at the Supreme Court. But in general, we tried to make the rules the same at the Supreme Court as they are in the trial courts so that people weren't having to learn two different systems. The registration is the same, the platform is the same. It's just the different kinds of filings that are different. And then the court has some of those different formatting requirements. I don't know, Judge Morris, if you want to go into any more detail on the e-filing rules.
There's only one point that I would add, and that's that with regard to a self-representer who's a non-e-filer who elects to e-file, has particular standards in the trial court for withdrawal from that status that are a little more stringent. Good cause is required. And the reasoning there is the pace of motion filing and treatment and avoidance of prejudice to other parties in terms of being able to provide notice of a request and the documentation, or respond to something that the self-representer is filing. In the Supreme Court, under the amended rules, as Emily has outlined them, a self-representer who has elected at the trial level to e-file would continue in that status on an appeal, whether they're appealing or another party's appealing. However, they can withdraw from that status and go back to non-electronic filing simply on providing notice to all the other parties in the court at the last electronic filing address of their change in status. Court permission is not required for a self-representer on an appeal to return to paper filing status. That's the only other change.
And maybe one thing that I would just add to that is that since the pandemic began, the judiciary under AO 49 has been allowing self-represented litigants to submit filings to the courts through email. And that has continued. And I think anecdotally, and at least in our court, that is the preferred, instead of using the e-filing system, self-represented litigants do seem to be just emailing documents to the court instead of using that e-filing system. And the Civil Rules Committee, the court did direct in the last amendment of 2 amendments ago, maybe the AO 49, the Civil Rules Committee to look at a more permanent rule on email filing and email service, and that's currently out for comment.
Senator Carson?
Yeah, that goes to the comment I made earlier in our meeting, which is that pro se's evidently were not using e-filing much. And so they're doing it instead by e rather than.
They
by
are not
e-filing.
required to use e-filing. They can use e-filing. There's no prohibition on the use of e-filing for self-represented litigants, but they're not required to use it.
Right.
In my, just anecdotal experience, I don't have a survey of across the state or anything, that there seems to be a preference there to just send things by email instead of submitting it through Odyssey File and Serve. But they certainly can use the e-filing if they wanted
No,
to.
my understanding is they aren't. That it's too difficult for them and that they haven't been. So anyway, this again goes to getting input from the users of the system a little bit more directly in a focus.
Right, so I have not really seen, I think we had one self-represented litigant that has sent stuff through e-filing, but they are able to send stuff through email, and that seems to be a much easier mechanism for them to send stuff to the court.
Any other questions? Is that all that? I think I've got you through all
Yeah,
of it.
I know it looks like a lot on your, and I went through things very quickly, so I'm happy to review anything else if there are questions, but.
No, thank you. I think we're all set.
Okay.
All right. So is Judge Zoney available, or is Judge Morris pinch hitting, or?
Yeah, I'm going to be pinch hitting it. He's in earnest preparation to shortly take over his new job from Judge Grierson. So, so I can speak to the rule. I think we do just have the one rule on. I sent an email to Mike and copied everyone on Rule 7, but Emily reminds me that that rule was considered at the last meeting in June. And so it's post-comment, post-consideration on for promulgation consideration by the court. The one that's on the agenda is an amendment to Rule 11A4. And with utmost respect, I'm calling this the Lalonde-Benning Amendment to Rule 11. You'll recall that back in December, at the December 8th meeting, we had, the committee had proposed, the court had proposed a rule to follow the decision in re Benoit. In that case, just very briefly, was a case where there was an issue of whether a defendant had adequately preserved a challenge to a predicate conviction. We have, as you know, a number of enhanced offenses based upon prior convictions. Most common occurrence there is the DUI situation where DUI 1, DUI 2, DUI 3 goes to progressive penalties, crosses over felony line at a certain level. I think it's the third. It is the third. And often there's attempts to agree and result in a plea to a charge of DUI, but conviction on DUI 1, either for lack of counsel or another infirmity in the way the judge asks questions as to the entry of the plea. So the court in Benoit said to criminal rules, propose a rule for us that allows preservation of a challenge to a predicate conviction, even though the defendant's pleading guilty to the enhanced offense, to allow them to preserve a post-conviction challenge to the validity of the predicate. And this was to propose a preservation by agreement in the context of a written plea agreement with the state. And both the present chair and vice chair had indicated on December 8th, we should have a rule that allows a defendant to proceed to preserve in some fashion, even though the state is not agreeing to that. And so we went ahead in criminal rules, at least 2, if not 3 occasions since, considered a proposal where a defendant, and this is what you see in the proposed 11A4, even without agreement of the state, without a plea agreement, could, on the record of the entry of a plea of guilty or no contest to an enhanced offense, have a means of preserving that challenge in a later post-conviction relief proceeding. What we're talking about here is a situation where the defendant enters what we call a straight up plea. There is no with the state. And the reasoning behind that is that 11A3 is a package, so to speak. There must be a plea agreement that encompasses that issue of preservation. The thinking of the court being that it would be unfair to the parties and the court to have someone say, okay, I'm going to enter into a plea agreement now, and then state on the record, but wait a minute, I want to preserve a post-conviction challenge, even though that may have featured into the negotiation with the state about the plea, the charge, and the sentence to be recommended. And so the draft proceeds along the lines of the Benoit opinions, rationale to say, yes, a defendant may now enter a straight up plea. In other words, I'm pleading guilty. I know the maximum penalty on this is a year or 3 years or even more, but I'm going to leave that open for argument and evidence and argument as to the appropriate sentence and the discretion of the court. That's frankly not often done because it's considered quite risky in terms of what might happen, who the judge is, and how they're approaching the evidence in the case, or what the state's going to put on for evidence. But this allows and preserve the challenge later. And the text of the rule, as you see, 11A4 says that they have to state the specific grounds for the specific predicate that is going to be challenged later. And of course, it's left to the defendant to in fact challenge later. The PCR is post-conviction proceeding is totally independent from the case right then and there in front of the court. And if sentence is imposed and no appeals taken, then that sentence is implemented. The defendant may have the right to make that challenge to the conviction, but it does not delay or defer the sentence in itself. So in a nutshell, this amendment responds to the concerns raised by Representative Lalonde and Senator Benning back on December 8th, when we talked about the 11A3 amendment. That one has gone into effect. The 11A4 was published for comment and closed comment on October 4th, and we've received no comments with respect to that amendment. That's a description of 11A4.
All right, thank you. Are you satisfied with this?
Well, I was going to ask you if you were disappointed that our names weren't enshrined in the recorder's notes.
I think I'm pleased with that not being the case. Any other questions? I appreciate the work on this, certainly, though.
See, we do listen and we do respond, and we think there's wisdom in what we hear as part of this process.
Well, I don't know if I'd go that far, but okay, I appreciate it.
Yeah, and the email that I had sent was regard to the amendment of Rule 7, which was amendment of indictment or information. As Emily said, we'll make a recommendation to the court. You have in front of you by the email. If you've seen it, it's kind of late in time. That's what would be sent to the court. And that was reviewed without any objection or comment on June 18th, the last meeting. So.
And that's Rule 7 on the criminal procedure.
Yes. And I'm sorry for that. I kind of jumped the gun and felt that this should be back on the agenda, but it was favorably reviewed by you at the last meeting, and it's on for promulgation recommendation.
Okay. Appreciate that.
You're welcome.
So, moving on then, let's see, no other questions. Is Alan Case available?
I'm here.
Again, I apologize, Alan. Is it Keys or K?
It's Kai's, like the last four letters.
Yeah, I knew I was getting it wrong, and so we're moving on to Rule 7B, 56C, and 78 of the Vermont Rules of Civil Procedure. Over to you, Mr. Kais.
Thank you. This package,
Judge Morris, I apologize, Judge Morris. Are you on for another one as well before we move on to?
No, I'm all set. I may listen for a bit, but I thank you. It's good to see you and participate again, and I will not expect to speak again. Thank you.
Thank you, Judge Morris. I apologize, Mr. Kais. Over to you.
this package does two things, basically. It consolidates into one rule the motion procedure that was formerly contained in two rules, Rule 7 and 78. So we put all the procedure into Rule 7 and abrogated 78. And the second thing, and I think is why it prompted the look at Rule 78, was to grant an extended time for responding to dispositive motions. Instead of 14, as was the usual for a motion, it's raised to 30. My memory is this was raised by our VBA representative, who pointed out that the federal local rules allow 30 days, and that in general, 14 days is just too short to respond to a summary judgment motion, for example. So the rule says a summary judgment or other dispositive motion has 30 days. And the rest is pretty much the same as what existed. There might have been some tinkering. The reference to Rule 56 is we added to Rule 56 that a reply memo can be filed within 14 days to make sure that people who are reading 56 knew that. But other than that, I think the basic of the rule is the dispositive motion gets an extended time. And now you only have to look in one rule to find out what motion procedure is.
Any questions on Rule 7B, 56C, and 78? I don't see any questions, so move on to, and this one's been promulgated, I see, okay.
Right. All the rest are proposed.
Yep.
16.3 is the mediation rule, and this is the first of several rules that we have proposed and will continue to propose that take provisions of Administrative Order 49 that people found worked and were good, and are making them permanent. Remote mediation works. We polled the mediators, and they were all unanimous that it's a good procedure. Most lawyers agreed that remote mediation worked. We had to figure out, there has to be some default. It's either going to be in person or remote. And I think there's still a general feeling that in person has a certain aspect to it that might enhance a settlement that people being not in the same room or same building together would have to achieve a settlement. So we made the default is in person. And as proposed, the rule says for good cause, the judge can order remote. We've already had our own internal comment about the rule. We had a debate initially and couldn't come up with a good compromise, but we've reached I think a better proposal to say in the court's discretion, remote mediation can occur. So that's the in the court's discretion is the phrasing we're going to be recommending to the court after our next meeting. We only had one, other than the internal comments, we had one comment from a mediator who said, there's some references to the initial pretrial stipulation, and it's just too early to decide the format of a mediation when you decide who the mediator is going to be and what the discovery schedule is. So make some proviso that makes sure that people can really up to the last minute choose to go remote. And the committee voted to ask the reporter to draft a clarifying comment, which will come out when it's finally recommended.
So will we have an opportunity to see those changes before it's promulgated?
I expect at our meeting in a week from Friday, the committee will vote and the language is all drafted.
Right.
If you want to see an advanced copy of what we're going to vote on, or you want to see it once we vote, we can do that.
I guess I'd ask legislative counsel, if we wanted to see this to comment on the language that's going to be promulgated, Eric, would we need to get this back in advance, or how does that work?
Yes, ordinarily.
And ordinarily, we will get it back?
No, ordinarily, the practice is that all comments are made, and that would be comments that they've received from the bar, comments that they've received from the committee during the course of the meeting. Then the rules committee incorporates or doesn't incorporate as it sees fit the comments, but whatever changes it makes in response to the comments, people will see when the rule is promulgated. So there isn't usually an interim step where the committee, or I don't think anybody else even, reviews the revised rule with the comments in it before promulgation. That review, I think, usually happens during that 60-day window after the rule is promulgated. That doesn't mean you can't if you have time, or you couldn't ask the reporter to send it.
No, I guess it would just be, I mean, from what I've just heard as far as what the changes are, I don't see why we would need to, but I'm just looking forward if there was going to be some sort of major change based on the comments, whether we have an opportunity to
Look at them again.
Yeah, please, yeah.
The only thing I would say is that if comments are received and there's going to be a pretty major amendment to the rules, then either the committee on its own or at the court's suggestion, those rules then usually go out for comment.
Okay.
So if there are kind of minor changes or changes in the reporter's notes to explain something more, or and I don't know, maybe Kim can as past practice, but certainly since I've been working, if a rule really gets quite an overhaul, then it usually does go out for comment.
All right, appreciate that clarity on that. Okay, thank you. Any other questions on Rule 16.3? I don't see any other questions, so moving on. 3.14 and 84.
Okay, these are in a way a hodgepodge. 3.1 is the what used to be called that Latin word. You get fees because you can't waive because you can't afford it. We had amended this rule to, I guess you'd say, liberalize the provision of free services to the free judicial services to the poor. But somehow the word household got in there, referring to household income, so that the clerks were dealing with forms that required them to ask, who do you live with and how much money do they make? And it was contrary to the intent of our original amendments that income outside that of the recipient or the person seeking the waiver would be considered. So we changed the word household to applicant, something like that. And in the meantime, the court has changed the forms.
Okay.
4 relates to 84. So I'll jump to 84. 84 is the appendix of forms and the rule that says these forms are sufficient and illustrate the brevity and clarity with which we want you to file your pleadings, but there's no technical pleadings. For one, the federal system has abrogated this rule and the forms. The federal note says they've served their purpose of illustrating how non-technical the rules are supposed to be, but we're not really in the business as rules makers of providing forms. We've also been here in a system now that's all electronic. The court administrator is putting forms on the website. There are formalized procedures where how those forms are developed and reviewed by the judicial oversight committees. So what the committee has done is consistent with the federal rule, abrogate the appendix of forms that make a statement that the where to find the forms now is on the judiciary website. And I'm not sure, I'll have to take a look at 56, but the other amendments in this package have to do with where in the civil rules themselves forms were referred to. So in Rule 4, there was a form for a waiver of service, and there are other forms referred to in the rules, and those now have been changed to instead of referring to the appendix of forms, referring to the forms approved by the court administrator.
All right, thank you. Questions on Rule 4? That's pretty straightforward. I don't see any question. So we're on to Rule 56. Did you have a question?
Can you help me out on this? I've got to change a screen here to look at it.
I'm
Or not.
having the same problem.
Okay. Okay, I think I found the right. Oh, this is not minor. I'm sorry.
What is there?
The change to Rule 56 is fairly substantial. I think it was Judge Stewart, but it was one of our trial judges said, it's getting really difficult to process a Rule 56 motion because the people don't respond to the facts. You're required to lay out the facts you claim are undisputed, but the opposing memos, if they do respond to the facts, they don't do in a consistent fashion. And I guess you might analogize it to a bankruptcy schedule. If you're looking at bankruptcy schedules for certain information, you want to look in the same place every time, not a different place every time. And so the idea was require the opposing party who objects to the disputes the facts to repeat the fact in question and then state their position as to each fact. And we may have had some models, but it's not a unique position to do that. The second thing that we addressed was the tendency of opposing parties to file factual statements. Instead of saying, I dispute your fact, they file, here's facts that I say are undisputed or I say exist. And it gets kind of confusing when you're asserting new facts. So it's decided it's not improper to say they're facts that should be considered, but it should be in a separate document. There's a document that says, here are the facts I dispute, and there's a separate document, here are the additional facts that I say should be considered. So that's basically the guts of that.
So,
And curiously, the 14-day to file a reply memo is deleted because we've dealt with that in another place. So that's,
I'm sorry, was there more on that one or?
no, well, there is more, is that the proposal where we were going to move that 14-day, we already received a comment that you should remain specific to say this 14 days from such and such a date or whatever it was. So we'll probably revise what we did there, but I don't think we're going to revise this deletion, which you're considering now. The main issue is, is a fairly substantive change to the way summary judgments are handled. Just as the facts must be set out separately numbered, must the disputed facts be set out separately numbered, and any additional facts put in a different paper. That's what the rule says, as proposed. We've received no comment on it so far.
Any questions or comments from committee? I had just one comment or question, I guess. In the subsection C3, it mentions the right to a surreply, but it doesn't follow the same kind of guidelines with respect to numbering facts that were in the reply. And I'm just wondering if, just flagging that, it might, I mean, for the discussion of the opening brief, the response brief and the reply brief, it has pretty detailed that you got to number the facts and you have to number the facts that you're disputing or all of the plaintiffs, or I'm sorry, all of the opposing parties' facts and then respond to them. But that same procedure is not really in with respect to the surreply. Just a question of whether it's necessary or not looking, it's not a big deal, but I just thought I'd flag that.
Yeah, I'll take that up with the committee. I didn't mention that in the Rule 7 business, one of the comments we got is we had what existed, which is the motion, the opposition, and the reply, but there were some comments about surreplies, and the committee came up with I guess you call it a compromise, is not to allow it necessarily, but to allow it in the discretion of the judge and giving some criteria. So that's in Rule 7.
Right.
But I'll take this up with the committee about if a surreply deals with disputed facts, should it be in the same format as a opposition?
Right. That's all I had on that. I thought otherwise makes me almost want to file some Rule 56 motions.
I think I missed.
So if there are no other questions on that, we'll move on to, let's see, we have proposed Rule 5A and proposed Rule 11E.
Okay. 5A, Emily just mentioned. We, as a result of the pandemic and Administrative Order 49, we found that email filing and email service is convenient. And this proposed rule tries to codify how to do email service and how to do email filing. We've received no comments. I have a number of questions to pose to the committee about it, particularly, well, about both the filing and service end of it. So I'd be happy to learn of any questions you may have.
Any questions from folks? I just had a couple questions. On page 4 of the rule, this is probably fairly straightforward. There's the standards for email filing. It says the filing must be sent as an attachment to the email account for the unit where the filing will be made. Is the email account for the unit, is that well understood, easily accessed, easily determined for pro se plaintiffs, for instance, to be able to send it to the right place? Yes.
I understand that it's on the website, but if you assume pro ses don't have internet, then I'm I'm not sure of the answer to that.
Yeah, I just wanted to flag that because I could imagine somebody trying to email or people in the court.
As an aside, this rule doesn't include email filing in the Supreme Court, and my plan was to get through the details of this before we propose a Supreme Court rule. But the Supreme Court rule is easier in this respect because there's an address we can put in the rule. So
Right. So I'm just wondering if you even have the address of each that's in the rule itself. So it's very easy for the individual to email the right address. The other question, and this has to do with this particular rule, but also rules that are being abrogated a little later. I don't remember which one, 60, maybe it is 26C. Is the committee taking into consideration, or does it need to, the fact that United States Postal Service service is slowing down and is taking longer? And I'm looking particularly at page 4, timeliness, that filing by mail shall not be timely unless the material filed is received within the time fixed for filing. Maybe it's the filer's fault if they are trusting the U.S. Postal Service instead of getting a commercial carrier. I don't know, but I just want that's taken into account during the conversations on filing.
I guess we haven't specifically talked about it, but to jump ahead, we are proposing to abrogate the 3-day rule for service by mail. And the theory is that it's just an exception that causes a lot of confusion, and that mail is almost never used anymore, that everything is going to be e-filed or emailed. And there's also the alternative of commercial, FedEx type delivery. And if there is a problem with the mail, that can be dealt with, by a request for an extension to the court. So we're, I guess, assuming mail is not going to be the primary means of getting papers to the court.
So it sounds like it has been taken into account. That was my main question. It sounds like it. So I appreciate that. Any other questions on that rule or those rules?
So one thing I invite your feedback is that for example, on email service, the statement is pretty simple. It just says you serve by email on an address consented to by the other party. And the rule contains no details as to, or at an address consented to. We have an existing system where they're registered addresses, and email services to go on all 3 addresses, and that doesn't seem to be in this draft. It might be advisable or might not be advisable to require some things in the subject line of an email service so that the recipient would know I'm getting served. Or is that all to be left to the consent that's on file? This is a question I'm going to pose to the committee. Are you content with just saying email service is okay if there's a consent, or should we have a pattern in the rule that everyone must follow?
I think whatever is easiest for pro se plaintiffs primarily is the standard that at least I look at. But would defer to the committee on that kind of issue. Any other different opinion on that here?
Enough about it. John?
Just trying to play through my head how that would work for somebody, especially an inmate. No inmates are addressed in a separate paragraph.
That's only mailings by inmates, not emails by inmates.
There's special prisoner email postbox rules that have been developed, I think, in both civil and the criminal rules. which give a grace period or a benefit of the doubt with regard to the mailings from inmates.
They just say that for the date it's filed when they give it to the prison.
Well, if I'm reading that rule correctly, document filed by an inmate is timely if deposited in the institution's internal mailing system on or before the last day of filing. I would never ask the question or seen an inmate filing where I can confirm that the institution has a mailing system that records the date that thing has been deposited. I do know I have received emails from clients who are in institutions which seem to extend a week or more out from the day that the inmate wrote the date on the letter that was being sent. And I've wondered what the delay was. So I'm just rolling through my head how this new change would impact that, if it impacts it at all.
The email filing rule was a result of, I think, of a US Supreme Court decision that said it was a constitutional right for a prisoner to have his filing filed as of the date he put it in the mail, something to that effect. And we investigated and talked with the people who run the out-of-state prisons, or people who knew about them, Defender General's office, and didn't have that problem that you mentioned of there being no legal mail system. We were given to understand that there is a legal mail system where an inmate can put an envelope addressed to a court and not have it opened and mailed at a date stamp mailing.
Yeah, my question is the timing of when it arrives at the courthouse and whether it's considered timely filed.
Yeah, the purpose of the rule is to make it timely as of the time it's mailed.
But is there a recording in the institution that indicates the date that it is actually being mailed? Is my question.
You're testing my memory. It may be we required a declaration by the inmate of the date he put it in the box.
That the inmates can, the rule says that they can do a notarized statement that it was deposited in the mailing system on a certain date. So there's nothing that I know at our court we have asking for that kind of statement. File something saying I put it in the box.
Okay.
So
I trust that I'm bringing up something that's not really a problem, but it just occurred to me that I have received letters from inmates that I have waited on for a very long period of time, knowing because they spoke to me by phone that it was coming. They have stuck it in the mail somewhere. I was never aware of whether anybody at the facility kept a track record of when they mailed it. So I'm just thinking what happened to me and wondering how it fits into this particular.
some institutions do keep a record,
Okay.
and some don't, and so the inmate, if they don't, the inmate. Put it in the process.
But you're essentially saying then that the inmate has to produce a certificate of service as to when they deposited it.
That's my memory of our rule. And, it's difficult when you're a rules drafter because you might remember only a draft and not the final version. So we're in the process, and hopefully we'll have something to recommend to the court after our next meeting of a rule detailing email filing and email service, followed up by a rule in the Supreme Court for email filing.
All right, I think that we're good with that one, and moving on, Alan, to rules 43 and 54.
Okay, let me go back to Rule 11, which is part of the Rule 5 packet.
Sure.
This again is an artifact of Administrative Order 49, in that we essentially adopted or adapted the federal declaration statute, which says if you need something under oath to be filed in court, it's okay if it's not under oath, but you declare it to be true under penalty of perjury. We limited the rule to requirements for oath made by rule. The federal statute applies to requirements for oath made by rule or statute. And we've received one comment on that saying, full speed ahead. This has been a great boon to us during the pandemic to be able to, in essence, prepare an affidavit without a notary public. And so I expect we'll see this rule being recommended to the court. The other aspect is the drafter of the rule went through all the tried to survey all legislative requirements for oaths and which were appropriate for the rule and which were not appropriate, and made a list of exceptions if we were going to have a broader statute. But we didn't choose to do that. Kinvin has written a letter to Eric saying, here's a list of statutes that maybe you want to consider whether a declaration would be appropriate, or something to that effect.
That was the one question I had about here, was whether we should review where in statute we should go to this requirement. But it sounds like you sent something to Eric, or Kinvin sent something to Eric.
Yeah, that's my memory, as I said, is there was, we'd done the work and we figured here's some you should know about this. But if I'm wrong, we'll try to get something to Eric.
Did you recall receiving?
I think so. My memory is vague on it, to be honest. So if it could be resent, just to be sure, that would be
Yeah,
much
if that
appreciated.
could be resent, if it could also be copied to me as well, that makes sense. That will probably be a bill drafting request.
Right.
I'm fairly sure I'm misremembering it, but I have, as I said, I have a person who worked extensively on reviewing the statutes and deciding whether we should apply this declaration rule, and I can ask her to provide that list to Eric.
Yeah, please have it sent to Eric and to me, Alan. And you can even put that down and feed in the queue now, Eric, because that makes a lot of sense.
That sounds good.
I've actually had somebody ask me about doing that, and I hadn't pursued it, but.
Yeah, the next item is where we did this. The proposed rule 43 and 54D is correcting a cross-reference to Rule 78, which we did not change when we abrogated Rule 78.
Right.
So we had to decide whether those rules now referred to Rule 7. And that's what we decided, and we proposed to change the cross-reference to Rule 7. And that's where, boy, my memory's bad on that. That's where Kinvin sent the letter to Eric saying, here's some statutory references to Rule 78 that you might want to change to Rule 7, or decide whether they should refer to Rule 7.
Okay. That would be a miscellaneous judiciary kind of issue.
I think so.
All right. Okay, going on to our last couple items, unless you had a question on the,
No, I have a question after
after the last.
60 and 26.
Yes, 60, and I'd love to see Day is a Day coming back again. I always appreciate that. So on to rules, the abrogated rules. Over to you, Alan.
Yeah, I've already talked about the 3-day rule being abrogated. That's Rule 6 and Appellate Rule 26, on the theory that it's inconsistent with the day-as-a-day counting and just too confusing for clerks. And given that everything is electronic or email, unnecessary. When I proposed to my committee that we abrogate Rule 6, I asked, are there any time limits that are too short that, should be extended because of this, eliminating this extra 3 days? And I didn't get any response. I do remember when going through the day as a day project and looking at some of the short time limits, there were some 3 and 5 day time limits. Should they be 7 or should they be 14 or should they remain short? I think we extended everything that seemed to be needed extending. So the exception to that is in the appellate rules. The 3-day abrogation first came up in the special appellate committee, Justice Dooley's committee that rewrote the electronic filing and appellate rules. The idea that the 3-day rule is obsolete came up then, and the practitioners involved said, yeah, but some of the time limits are too short. And so it was discussed there, and then my committee approved some extension of the rule times for appellate briefs, from 30 to 40 days for the principal brief, from 21 to 30 for the appellee's brief, and from 14 to 21 for the reply brief. And so that's the amendments to Rule 26. And there's also, the appellate rules have had this automatic extension if the other side agrees, but with a certain time limit being equal to the time of the limit you're extending. And so those were extended. So on a appellant's brief, which was 30 days, you could get another 30-day extension. If the other side agreed, now it's 40 days and you can get a 40-day extension. This, if you add them all up, this extends the time for processing an appeal, perhaps by a significant amount, I don't know, but the appellate specialist did want some additional time baked into the rule. So that's what we've done in this proposal.
Any questions or comments? I'm not seeing any. I think we're fine with that as well. Like, I appreciate that. I think that's it as far as the rules, though I know that Senator Clarkson has.
I just have a question to Eric and Emily, and to Alan maybe, or whoever's dealing with the probate court. We were sent a proposed thing in all the pieces Mike sent us to read to prep for today. There was a proposed rule change in Rule 66. I got a whole proposal changes to Rule 66, which have to do with the inventory and rules around probate court. Was I not meant to be sent those? Because I have feedback on. So
I think it's inadvertent. I don't remember it being.
If you look at Mike's email from the 15th of October, the last thing that's on there is a proposed rule change to Rule 66. And I was just wondering when we were taking that up, and B, how can I send comments to it? Who do I send the comments I've gathered?
So where's that in the process? Yeah, we'll look and see what that is in the process if we're going to have Kenton, is that something you know as far as where Rule 66 and probate is in the process right now?
As I understand it, it was on the first agenda that Eric went out and sent out, and has vanished in the revised agenda without my being quite clear why that had occurred.
Yes, I'm puzzled why it's, anyway, it's not in our materials, but it was in the email material. So I'm just curious how long, if I should make the comments now, or if I should send them to somebody who's working on this.
Well, I guess since it's not on this agenda and Judge Kilgore, the chair of the committee of the Probate Rules Committee is not with us,
So should I send them to him?
send them to him and me, I guess, and presumably this will reappear on your agenda at a later time.
I know, but if I don't do it now, it won't. It's at the top of my, so I send them to you, Kinvin, and Eric, would you be kind enough to get me Judge Kilgore's?
Yeah, Judge Kilgore is the chair of the Probate Rules Committee.
Great. Thank you.
Yeah, I don't recall them ever being on it. I don't know how they got on there.
Yeah. and
Well, they're there. I read them.
Huh.
I would have read them if I had seen them, but.
Yeah, they're
so,
there in Mike's thing.
Interesting. I missed that.
Well, you were clearly way ahead of things.
So that's it then, I believe, for today. And there's still an outstanding issue of deciding when and if at least the Judicial Rules Committee will be taking up a review of AO 49 venue as opposed to some other entity legislature. So,
Or maybe together.
yeah, it could be. There may be a lot of overlap there as well. So I believe that's it. So I suppose I could take a motion to adjourn, but we're not a quorum anyway.
Well, to that end, I think that we should make a special plea to our colleagues perhaps that we couldn't actually conduct some business today without more people in person. So
Yes.
I think we're missing. We're just missing. Keisha would have made it
Yeah,
possible.
I think Senator Hinsdale is the only one that, I mean, Maxine was on for a little while remotely at the beginning.
Yeah, as was. Yeah.
So, all right, well, thank you very much, everybody. I appreciate it. And we'll see you next time, whenever that is.
Great.